My name is Mark Berry. I'm a staff attorney and the lead housing attorney at Veterans Legal Institute. Veterans Legal Institute is a nonprofit law office which provides free legal assistance to homeless, low-income, and elderly military veterans. Veterans Legal Institute's housing department assists veterans with evictions, security deposit disputes, reasonable accommodation requests, and other landlord-tenant related legal matters. Today's video is a brief guide to provide you with general knowledge about the steps which you must take if you are facing an eviction from your home. The following which I'm about to present to you is general and non-case specific information for educational purposes, and this is not to be construed as legal advice. For specific information regarding your case, you should schedule a consultation with an attorney as soon as possible. Although Veterans Legal Institute's mission is to provide legal services to low-income, homeless, and elderly veterans, the information contained in this video applies equally to any tenants facing eviction. Now, what is an eviction? An eviction, which is formally known as an unlawful detainer, is a frightening, confusing, and uncertain time for most tenants. Many tenants who are facing eviction are already under severe financial and personal stress, even before the eviction begins. For countless people, evictions are their very first exposure to the court system. But make no mistake, your eviction is a legal proceeding, and it will be decided in a trial before the judge. An eviction will often lead to life-changing consequences. Losing an eviction case can mean being kicked out of your home, possibly losing all of your personal belongings, experiencing homelessness, and being blacklisted from renting a new apartment for up to 7 years. These are consequences which rival the severity of a criminal arrest and conviction. But unlike criminal defendants, tenants who are facing eviction do not have a constitutional right to be represented by an attorney in court. This means that in over 90% of eviction cases, the tenant is unrepresented in court and has to navigate their entire case without any help. In contrast, your landlord will probably have an attorney representing their interests in court. Worse, unlawful detainers are given priority by the court system, and they move along so quickly that tenants often do not realize that they're giving up their chance to fight their case before they even realize it. More than 50% of unlawful detainer cases end in a default judgment simply because the tenant did not realize or did not fail to respond to the eviction, and they lost their case automatically. Despite this lack of knowledge among most tenants regarding the complexities of eviction proceedings, the courts do not consider ignorance of the law as an acceptable excuse. Fortunately, as long as you follow and remember the following principles and steps which I'm about to give you, you will greatly increase your chance of fighting your eviction successfully, of having your day in court, and even winning your case. Part 1. Notice to terminate the tenancy. Prior to the start of an unlawful detainer case, your landlord must serve you with either a written notice to do some act or otherwise return possession of your apartment back to your landlord, or alternatively, your landlord must serve you with a written notice that your tenancy is being terminated after a certain period of days go by. Your landlord must serve that notice to you either by personally handing it to you or to another adult living in your apartment, or by posting a copy onto the door of your apartment and mailing another copy to you. If the notice requires you to do a certain act within a certain period of time, you must carefully review the notice to know which act you are specifically being required to perform. The most typical form of notice is a 3-day notice to pay past due rent or surrender the property back to your landlord. This is commonly known as a 3-day notice to pay or quit. The 3-day notice to pay or quit must state how much rent you owe to your landlord, let you know that you have 3 days, excluding Saturdays, Sundays, and court holidays, from the date of the notice being served to pay back your rent, and it must provide the contact information of your landlord or their representative. Keep in mind, you are required to pay your entire overdue rent, and if you fail to pay the entire amount of the rent back to your landlord within 3 days after service of the notice, your landlord will be allowed to go to court to file an unlawful detainer and then evict you. 3 days is not a whole lot of time, so more likely than not, if you cannot pay your rent back within those 3 days, you are going to be facing an eviction. After the end of those 3 days, your landlord is no longer required to accept any additional rent from you, even if you're able to pay back all of the rent you owe. Some other notices include a 3-day notice to cure a lease violation or quit the property. For example, if you break a lease rule regarding pets on the property, or if you smoke on the property in violation of another lease rule. Other times, your landlord could serve you with a notice to terminate your tenancy without giving you any opportunity to do something. For example, your landlord could give you a 30 or 60-day notice to quit the property. Regardless, you should still carefully review that notice. You should carefully review it because in some cases, your landlord must still provide you with the reason why they are terminating your lease, and that reason must be included in the notice. Part 2, being served with the summons and complaint. After your notice expires, your landlord's attorney will go to court and file an unlawful detainer case against you. Soon after filing, your landlord's attorney will have you served with several important court documents, which include a summons and a complaint. The complaint is the formal legal document prepared by your landlord's attorney, which names you as the defendant in an eviction case. The complaint alleges that you have breached the lease agreement in some manner, such as by not paying rent, or the complaint can allege that your lease has been terminated for any reason or no reason, and requests the court for the remedy of canceling your lease, removing you from your apartment, and awarding any money damages and possible attorney fees to your landlord. The summons is a document notifying you that you are the defendant in an unlawful detainer case and warning that you have only 5 days to file a response to the complaint with the court. These 5 days exclude Saturdays, Sundays, and court holidays. Other documents served with the complaint include a pre-judgment claim of right to possession and a mandatory civil cover sheet with supplemental allegations. For the purposes of this video, we're going to focus on the summons and the complaint. When you are served with the summons and complaint, you will either be personally served by a process server who will hand the documents to you, or hand the documents to another adult who resides on your property, or the process server will post a copy of the documents to the door of your apartment and mail another copy back to you. Being served with the summons and the complaint may be the most important step in the entire eviction case because this is the point where most tenants go fatally wrong. After you are served with a summons and complaint, you have 5 days to go to the court where the case was filed and then prepare and submit your answer to the complaint. If you do not submit an answer within those 5 days, your landlord's attorney will return to the court, request the entry of a default judgment, and a writ of possession from the judge. That means that you have automatically forfeited your case, and the landlord, once these documents are approved by the court, will be permitted to request your county sheriff to post a 5-day notice onto the door of your home, warning you that you must leave the property permanently at the end of those 5 days. This is not a mistake that you want to make. Even if you believe that you cannot win in court, or you otherwise decide you don't want to fight your case in court, you still should file an answer to the complaint. Filing an answer has several advantages. It allows you more time to stay in your apartment. It allows you time to prepare your arguments and your evidence for the court. Furthermore, if you get a default judgment by not filing an answer, your case will automatically become unsealed and become a visible public record for a period of 7 years. This means that other landlords will not rent to you in the future because they will perform credit checks on you when you're applying to an apartment, and they will not want to rent to a person who has an eviction on their record. However, if you go to trial and lose, you can still ask the judge to seal your case to avoid the consequences of having an eviction on your record. When you go to court to file your answer, you should seek the assistance of the Self-Help Center with the filing. Although the Self-Help Center cannot provide you with specific legal advice regarding your case, they can still help you with preparing and reviewing your answer, with requesting a fee waiver so you're not required to pay a several $100 filing fee, and mailing a copy of your answer to your landlord's attorney. Common defenses that you can use when filing your answer include the implied warranty of habitability. In cases involving the non-payment of rent, you can assert the implied warranty of habitability as a defense. This means that every apartment must be fit for human habitation as a condition for paying rent to your landlord. Therefore, your apartment cannot lack basic necessities such as heating, running water, electricity, and gas. It cannot suffer from a severe mold or pest infestation. I should note, though, lack of air conditioning is not considered a breach of the implied warranty of habitability. A tenant who is being evicted for non-payment of rent and who has a habitability problem at their apartment can assert this breach of the implied warranty of habitability as a defense. Number 2, lack of just cause. In certain apartments, the tenants are protected by a state law known as the Tenant Protection Act. The Tenant Protection Act protects tenants against excessive rent increases and also protects tenants against evictions without just cause. For example, a just cause reason for an eviction could mean the owner wants to move into the property, to take the property off the market. Exceptions to the Tenant Protection Act include tenants who live in single-family homes, in duplexes, in apartments that are less than 15 years old. Those tenants are not protected by the Tenant Protection Act, and they can be evicted for any reason or no reason by their landlords. Number 3, in certain cases, if your landlord accepts rent after the notice period expires, that would be a defense to the eviction. Alternatively, in a non-payment of rent case, if your landlord refuses to accept your rent, your full rent that is, before the 3-day notice to pay or quit period expires, you are allowed to raise that as a defense to your eviction. Number 4, your landlord refuses your lawful request for a reasonable accommodation of your disability. For example, let's say that you are handicapped, you're unable to walk, and you have to use a wheelchair. You ask your landlord to allow you to make certain modifications to your apartment, such as installing a grab bar in your bathtub so you can hold it and not fall. If your landlord refuses to grant your request for an unjustifiable reason, that can be also raised as a defense to an eviction. Number 5, problems with the notice to quit itself. For example, if the notice to quit is defective in some way, such as it was not properly served to you, or the notice does not give you 3 days to pay your rent back, or the notice does not tell you where to drop off your payment, or if it's not specific about what other acts you need to stop doing, that can also be raised as a defense to your eviction. Number 6, your landlord can allege certain acts that you committed, but you do not believe that breaches the lease. In that case, you could argue that whatever your acts were committed were either not in violation of the lease agreement or were not severe enough to justify an eviction. For example, if your landlord gives you a notice to quit because you have an unauthorized pet on the property, but nothing in your lease agreement prohibits you from having a pet, that could be raised as a defense. Keep in mind, you should allege every single defense which is applicable to your case in your answer. Not all of the defenses that exist in unlawful detainers will be discussed in this video. If you fail to allege an applicable defense in your answer, you are not going to be allowed to argue that defense in court before the judge. Being unable to pay your rent, even if it's for a good, sympathetic reason, such as if you lost your job, or if you're a single parent struggling with money, or if you become ill, that is not a defense to an eviction, unfortunately, and a court will evict you regardless. Part 3, preparing for trial. Congratulations, you have successfully filed your answer, which puts you ahead of most other tenants and guarantees that you are going to have your day in court. But you should not be breathing too comfortably yet, because there are still many challenges ahead of you. After you file your answer with the court, your landlord is going to request a trial date. After your landlord requests the trial date, the court is required to set a trial date no later than 20 days after the landlord's request. In practice, though, this time frame differs from county to county. For example, in Orange County, where our offices are located, our courts typically set a trial date within 2 weeks after the initial request. In contrast, Los Angeles County trials can sometimes be set more than 1 month after the request. Once the court sets the trial date, the court will mail you a notice telling you which date your trial will be heard and what time and which courtroom you're supposed to appear in. In the meantime, you should gather up all the evidence to support your defenses to the eviction. For example, if you are alleging the breach of the warranty of habitability, you should prepare to bring photographs to the court showing the defective or uninhabitable conditions in your apartment, such as pictures of the rats and cockroaches, pictures of a non-functioning toilet, and you should also bring evidence that you told your landlord about the problems, but your landlord did nothing to resolve them. For example, you should bring text messages, emails, or even witnesses to support your claim. If you do not want to fight this case, you have the option of reaching out to your landlord's attorney to make a settlement offer, such as an offer to repay all of your rent in exchange for dismissal of the case, or requesting additional time to move out from your apartment in exchange for dismissal of the case. The advantages of this are that you may have an additional period of time to stay in your apartment, and your case will likely remain sealed after it is dismissed. Part 4, the trial. All right, you finally reached the trial, the moment you've been waiting for. First things first, though, you actually need to appear at the courthouse at the time your trial is scheduled to begin. If you fail to show up or show up late to the court, you will lose, and the court is going to enter a default judgment against you. Don't let that happen. After you arrive in court, the clerk will typically take roll call to determine whether you and your landlord's attorney are present. After roll call ends, you typically will have a bit of time before your case gets called by the judge. You can spend that time rehearsing your arguments and reviewing your evidence for one last time. Before your case gets called, you may have an opportunity to speak with your landlord's attorney about your case. If you are able and willing to repay all of your back rent, you should let your landlord's attorney know, and they may agree to a settlement which will allow you to pay and stay with dismissal of the case if you can pay back everything you owe. Alternatively, if your landlord refuses to allow you a chance to pay and stay, you can ask the landlord's attorney to grant you additional time to move out from the property, such as 15 or 30 days, in exchange for your landlord's dismissal of the case. Both of these scenarios will usually ensure that your eviction remains sealed, but you should ask the landlord's attorney to specifically include that as a provision in the settlement agreement. Assuming you want to contest the case, or if you cannot reach a settlement with your landlord, you should be prepared for your case to go forward. If you are certain from the beginning that you do not want to reach a settlement with your landlord, it is best that you try to avoid discussing your case with the landlord's attorney for the most part. Keep in mind your landlord's attorney is going to be very experienced with unlawful detainer cases and knowledgeable about the law, so they may present you with misleading information or otherwise confuse you or persuade you into foregoing your right to go to trial and reaching a settlement on unfavorable terms. Once the judge calls your case, you should provide the judge with a time estimate of how long your case will take. Your landlord's attorney will typically give a low time estimate, such as 20 minutes. That is not enough time for you to present your case to the judge, so you should tell the judge that your case is going to take more time. You should specifically tell the judge it will take, for example, 1 hour or 90 minutes or 2 hours. Keep in mind, if you go under time, that is not a problem, but if you go over the time, the court will usually cut you off. When the trial begins, your landlord's attorney will have the opportunity to present their case first. Typically, your department manager will testify as a witness to establish the basis of evicting you. You will have an opportunity to cross-examine the witness, although keeping in mind that this is your first time in an eviction case, it may be best to not ask any questions and to wait until it is your turn to present your case. However, that depends on the facts of the case that you're involved in. Afterwards, you will have an opportunity to present your side of the story, your case, to the judge. You should also present your documents to support your arguments. For example, photographs of the pests, photographs of the damage to the apartment, emails about your landlord not accepting responsibility for that damage. When presenting each photograph or document, you should state to the judge that this is a true and correct copy of the conditions that existed at the time of the photograph or document. Once you have finished, the court may allow your landlord an opportunity to rebut your case. Afterwards, the court will allow both you and your landlord's attorney the opportunity to make a closing argument. The judge will either announce their verdict at the end of your closing arguments, or they will take the matter under submission. Taking the matter under submission means that the judge will think over the case and send you their decision by mail. Prior to the verdict, and ideally towards the end of your closing arguments, you should ask the judge to order that the entire case to be sealed so it does not become a public record and otherwise inhibit your ability to find a new apartment elsewhere. Part 5, after the trial. If you won your case, congratulations, you are going to be allowed to remain in your home. Pat yourself on the back for a job well done. If you lose your case, the court is going to issue a judgment in favor of the landlord and will also issue a writ of possession, granting the landlord the right to have possession of the property. A few days after the judgment, the sheriff will post the writ of possession and a 5-day notice to vacate on the door of your apartment. At that point, you will be given 5 days, and 5 days includes Saturdays, Sundays, and court holidays, to permanently move out of your house. If you do not move out of your house by the end of those 5 days, the sheriff will forcibly remove you from the property. The sheriff will only give you a few minutes to leave, and they will not give you enough time to take any of your belongings with you. If you still have belongings on your property after the sheriff locks you out, you will have up to 16 days to retrieve your belongings. However, you're not allowed to come back onto the property to take them, or else you could risk arrest and criminal prosecution. Instead, you must coordinate with your landlord to remove those belongings. You may have to pay your landlord the reasonable storage fees for holding your personal property. If you do not recover your personal property before the end of that 16 days, depending on their value, your landlord can either dispose of them or sell them. In conclusion, when you are facing an eviction, you may feel completely lost and confused, and you do not know where to begin. But when it comes to navigating an eviction, knowledge is truly power. Having insight about the steps of an unlawful detainer case can make all the difference between losing and winning and having your day in court. But as you can see, this whole process is nonetheless confusing and technically complex. So if you are an attorney, I highly recommend that you take on an unlawful detainer case pro bono. It may make the difference between a tenant getting to stay in their house or losing their home and becoming homeless. We hope that this video will make that kind of a difference for you in your eviction case. If you need legal assistance with an eviction or another legal matter, you may visit our website at www.vetslegal.org. Thank you.